still eating. And I think there's more food if people want seconds. However, I want to get started with our program for lunch, which is we have an opportunity to hear from Bob Nagel himself. Before I turn the microphone over to Bob, I want to thank everyone for coming and thank the panelists this morning for a really interesting, thought-provoking set of conversations. And to say that after lunch and after Bob speaks and is going to take some questions, we're going to, instead of having dessert at the table, we decided it would be a good way to end the conference with a dessert and coffee reception so that people will have a chance to talk and interact with the panelists and each other for a while after lunch. So I think that will be sort of out around there, but we'll find each other. Again, thank you for coming, and now I'm going to turn things over to Bob.
Take my watch off, so I don't run over. A couple of preliminary things. Some of what I'm going to say is going to be repetitive for those of you who are here in the morning session. I apologize for that, but not only am I unable to depart from my prepared text, but also there are a lot of new people here who haven't heard what was talked about this morning, and so I think it's worth a little bit of repetition. Speaking of the panels this morning, I want to say that I had two sort of different reactions that I want to mention before I get to my remarks. After the first panel, I really have to say, I thought, well, if I was so insightful as a law student, and in effect I saw why I should have seen why I shouldn't condemn myself to a career reading constitutional opinions of the Supreme Court, and then I went ahead and so I couldn't have been all that smart, because I did it anyway. And secondly, the cumulative effect of both panels was quite different from that, and much less depressing, I think, or at least disturbing. And that is to listen to people who are so serious about their subject matter and so thoughtful and so capable, made me realize that really I hadn't made a mistake in coming into this profession of law teaching, and reminded me of what I find and have found worthwhile and admirable about it. And I would say that even if they weren't talking about me. I think. Now, I do want to take a minute to thank each of you for coming here, being here. It means a great deal to me. I also want to express my gratitude to Melissa Hart. She organized the event. I know it's very difficult to do. Takes a lot of time and effort. I appreciate that. And also the efforts of Julianne Williams, who made the practical arrangements, which is also a difficult thing to carry off as well as she has. And as I've already indicated, I very much appreciate the contributions earlier of the panelists. The last thing I want to say in a preliminary kind of way is I do need to acknowledge two of my former colleagues, Stephen Smith, who could not be here because he's in Rome, But he did submit a very thoughtful essay for publication with the other conference papers. And Richard Delgado, who first suggested the idea of holding a conference for the purpose of evaluating my academic work and marking my retirement. I thought I would use this time not to unveil my answer to some question in constitutional theory, but maybe somewhat perversely, in light of the occasion, to raise a question that I will be researching and thinking about over the next several months. If nothing else, I hope to give you a sense of why I think this question is worth working on, and thereby provide a glimpse into how I have tried to make responsible use of the great privilege and freedom given to me as a member of the university faculty. One last preparatory comment, and that is I want to provide you all with the first trigger warning that I have ever given. I'm going to focus on cases that involve controversial moral issues, and I'm going to be criticizing the court's decision-making, but I don't want to be misunderstood. I recognize that some or all of the court's decisions have achieved important moral objectives. My concern has always been whether the practice of relying so heavily on the federal judiciary is in the aggregate good for our institutions and our political culture. Today, my specific concern is about how morally significant decisions should be made and why in modern America we have turned to the court so often to make them. In 1973, a year after I graduated from law school, the Supreme Court decided Roe v. Wade, establishing a constitutional right to abortion and invalidating the laws governing abortion in all 50 states. Last year, very near the end of my 40-odd-year career as a law school teacher, the court decided Obergefell v. Hodges, establishing the right of same-sex couples to marry, and thereby altering the understanding of marriage that had existed everywhere throughout history until that understanding began to change about 15 years prior. Recall that President Nixon began replacing members of the notoriously activist, or gloriously activist, depending on your point of view, Warren Court in 1969. As few of you may remember that Nixon had run partly on the promise to rein in an out-of-control Supreme Court. By 1972, Nixon had appointed Chief Justice Berger as well as Justices Blackmun, Powell, and Rehnquist. In the roughly 4 decades since, until Justice Scalia's recent death, the court has been numerically dominated by Republican appointees, all devoted, according to the presidents who nominated them, and to the nominees' testimony during confirmation hearings, to something called judicial restraint. Roe v. Wade in 1973 was authored by Justice Blackmun, who was joined by 2 other recent Republican appointees, Justices Berger and Powell. Obergefell v. Hodges, 42 years later, was authored, as everybody knows, by Justice Kennedy, who had been nominated to the court by President Reagan. This is where my question begins. Why did conservative proponents of judicial restraint have a significant role in 2 such politically progressive and jurisprudentially audacious decisions? I say that as the beginning of my question because over the past 40 years, there have been these two cases are only the tip of the judicial iceberg. Under the Berger Court, and then the Rehnquist Court, and then the Roberts Court, judicial control over almost all areas of American life has become routine. Beginning in 1971, the Warren Court's historic decision requiring racial non-discrimination in public schools, was converted into an ambitious nationwide campaign to achieve racial balance. Later, the court decided that a moment of silent prayer in school classrooms, not to mention student-led prayers at football games, are unconstitutional, as are many holiday displays, as is posted in the Ten Commandments in a courthouse. There have been a series of cases invalidating gender discrimination in everything from purchasing beer to admission to military schools, accomplishing through interpretation the equivalent of the proposed but never ratified Equal Rights Amendment to the Constitution. Protections for freedom of speech were extended to speech that intentionally inflicts emotional injury, distress, to commercial depictions of animal cruelty, and to violent video games sold to minors. The court significantly displaced core executive and legislative authority, for example, over confidentiality in the Oval Office, and both authorities over the treatment of prisoners of war. This listing could be extended so far as to war you to choose. And I might add, I am well aware that it could be extended to include activist decisions aimed at what are commonly thought of as politically conservative objectives, such as second-guessing Florida's method of counting votes in the Bush-Gore presidential election in Florida, the scope of the right to bear arms, and limiting the use of racial preferences. There is a tendency to explain this use of judicial power by pointing to individuals. Nowadays, Anthony Kennedy is often fingered as the unreliable one, and sometimes Chief Justice John Roberts. But previously, the named culprits have included Blackmun, and Berger, and Souter, and Stevens, and O'Connor. The list could be much longer. Even the arch-conservative Antonin Scalia participated in the growth and consolidation of judicial power, sometimes in progressive directions. In short, for 4 decades, conservative appointees ostensibly committed to a modest judicial role have helped to extend judicial oversight into almost all areas of American life, have made it extremely hard to distinguish judicial decision-making from executive or legislative decision-making, and have claimed for the court an almost authoritarian role in establishing constitutional meaning. You've probably read journalistic explanations for this phenomenon. If you were here this morning, you heard some of them recounted. It said that presidents have lacked the political will to really change the direction of the court, or that it's hard to predict the behavior on the court on the basis of prior performance, or that living in Washington, D.C., hobnobbing with the elites at dinner parties and in the faculty club at the Harvard Law School is corrupting, or that the justices all come from the same cultural and educational background, and so on. These realistic explanations are all partly true, I think, and in fact, I once tried adding to them, as you also heard this morning, at some length by arguing that the biases in modern legal education and in lawyers' professional habits of mind are partly responsible. But the question I want to explore in my current research plan is more philosophical. Is it possible, at least in our present circumstances, that conservatism as a political philosophy lacks some of the resources, intellectual resources, necessary to accomplish any significant change in the role and direction of the Supreme Court? To be more specific, let me make a quick comparison between the abortion decision and the same-sex marriage decision, more than 40 years apart, but intellectually very close. In both instances, critics did not argue that the decisions were merely mistaken or ill-advised. Dissenting in Roe, Justice Byron White, in his cryptic way, wrote, I'm quoting, "As an exercise in raw judicial power, the court perhaps has authority to do what it does today." You have to let that sink in a little bit. John Hart Ely, a proponent of liberalized abortion policy, wrote that Roe, and again I'm quoting, is not constitutional law and gives almost no sense of an obligation to try to be. You don't need to let that sink in. In Obergefell, all four dissenters argued that the majority opinion had, as the Chief Justice phrased it, nothing to do with the Constitution. Justice Alito wrote, quote, "What the majority opinion evidences is the deep and perhaps irremediable corruption of our legal culture's conception of constitutional interpretation." In both instances, the majority opinion is, shall we say, inexact about the textual basis of the constitutional right. Justice Blackmun tossed off that the right to privacy might be founded in either the 14th Amendment's concept of personal liberty or maybe in the 9th Amendment. Justice Kennedy indulged in a lengthier, almost metaphysical derivation of the right based on an interaction between due process and equal protection. In both instances, the court recounts in apparently respectful and erudite terms the long cultural history of relevant public attitudes, in one case on abortion and the other on the nature of marriage. In both cases, it turns out that this history is not determinative. In the case of abortion, it is not determinative because medical ethicists, legal thinkers, public health professionals, and others had never come to agreement about when life begins. In the case of same-sex marriage, history is not determinative in large part because more enlightened attitudes have recently begun to emerge. In short, in both Roe and Obergefell, past practices and traditional understandings, as well as currently prevailing political sentiments, are recounted or put aside. Unweighted from the historical and the political, the court is free to come to its own reasoned judgment. In both Roe and Obergefell, this judgment turns out to be quite original. On abortion, while the annals of human history could not produce a moral consensus, 7 members of the court propose a moral calculus whereby the woman's interest in privacy strangely diminishes with each trimester of pregnancy, while the state's interest in protecting potential life just as mysteriously increases. Thus, the court thinks of a solution that had somehow evaded all those thinkers across human history. On same-sex marriage, the court's solution is not so complex or so obviously unprecedented, as a number of states in foreign countries had recognized same-sex marriages by the time of the decision. However, the court does imply repeatedly, but without explanation, that while marriage is not necessarily between a man and a woman, it is necessarily between only 2 individuals. This despite the fact that polygamy has ancient roots and modern adherence in a number of cultures. Thus, the court thinks of a solution in the same-sex marriage case that departs from much of human history, not only in the right that it bestows, but also in the limitations it seeks to establish for that right. To summarize this brief comparison, both cases can be viewed not as law in any conventional sense, but as the operation of the unfettered mind relying on itself to arrive at an original solution to a difficult moral question. This suggests that conservative jurists may be unable to escape from the underlying commitment openly embraced by many progressives to the Enlightenment's faith in the capacity of the unencumbered human mind, that is, the mind operating independently of history and traditions. What do I mean by unable to escape? Surely, you might say, a conservative political philosophy and jurisprudence provide copious antidotes to the hubris of enlightened rationality. Think just of Edmund Burke's luminous writings on tradition and gradualism, or of Michael Oakeshott's critique of rationalism in politics, or of F.A. Hayek's defense of uncoordinated economic decision-making. Moreover, there is, again to use a very obvious example, the common law's focus on the specifics of the case and respect for the thinking of others that is embodied in the doctrine of precedent. These and other aspects of conservative thought are what I will examine more fully in the months ahead, but I want to focus for just a moment on the conservative commitment to reasoned judgment. That commitment, those words, were used by Justice Kennedy repeatedly in Obergefell, and he rightly traces those words to the great conservative justice, John Marshall Harper. What function does the idea of reasoned judgment play in conservative jurisprudence? An answer might lie in a crucial step that the court makes in both the abortion decision and the same-sex marriage decision, and indeed in most of the inexplicably activist decisions that the Republican appointees have been partially responsible for. That step is to define the right at issue abstractly or generally, or to use the terms the court sometimes uses, as a broad principle rather than a specific requirement. In Roe, the right of privacy is said to include abortion because the right to privacy is defined as including those choices that importantly affect the quality of a person's life. In Obergefell, the right to privacy is said to include the right to marry someone of the same sex because the right to privacy is defined as those rights that involve intimacy and self-definition. At this late stage of my career, I'm feeling reckless enough to assert that this move to abstraction, to broad principles, is the basic intellectual underpinning of modern constitutional law. It was authoritatively rationalized by probably the most influential legal philosopher of our time, Ronald Dworkin, who went so far as to argue that constitutional principles should be stated at the most general possible level. Those are his words. The effect of Dworkin's argument has been almost magical. It has allowed the modern court to believe that it is staying true to the original Constitution and to our traditions while redefining both. It has enabled the court to sit as a continuing convention of minds unencumbered by the past while claiming to speak for the past. It has enabled conservative justices to believe that they can do justice as they see it and remain restrained. This move to abstraction has not gone unchallenged. Justices Scalia and Brennan once exchanged pointed arguments about the practice. In a case involving an asserted right to assisted suicide, a majority of the court went very far towards adopting Scalia's positions that rights must be defined and limited by the actual tradition that recognized the right. More recently, the court has returned to its practice of generalizing the right beyond what was protected in tradition. One basic rationale for the rejection of Scalia's rather lonely position is that if a right is defined narrowly according to what has long been protected, the court's interpretations only reflect traditional understandings and thus do not, as they say, live or grow or evolve, or as some would say, metastasize. But of course, this hardly resolves the issue, since the question to begin with was whether the court is justified in changing the judgments inherent in historical traditions and practices. That is, the question was where growth and evolution should be initiated. We don't answer that question by assuming it's in the Supreme Court. We have to explain why. Another rationale which seems self-evident, at least to most of the students that I have taught over the years, and maybe many of you, is as Oliver Wendell Holmes Jr. wrote in The Path of the Law, quoting again, "It is revolting to have no better reason for a rule of law than that so it was laid down in the time of Henry IV. Why that word revolting? Because I think oldness, standing alone, by the way, this is a position I'm increasingly touchy about. Oldness standing alone is thought to cut against the wisdom or morality of a position. At a minimum, oldness by itself means the position is out of date and has not been passed on by our superior moral minds. This rather self-congratulatory answer, however, is in its own way revolting, because it unthinkingly assumes that the times have changed in some relevant way, and that a few modern minds, in our circumstances the minds of 9 Supreme Court justices, are superior to all the minds that accepted the policy or practice for all those years and in all those places. At least in the modern era, the conservative answer to these problems has by and large been that the court is justified in departing from received understandings if it uses and is restrained by reasoned judgment. But as reassuring as those words are, what could they mean? Is the thinking of the dissenters in Roe and Obergefell not reasoned? Are the beliefs of all those respected thinkers who throughout history hadn't imagined the trimester scheme or a conception of marriage as between two but only two people of either sex not reasoned? Or maybe they all had engaged in reasoning but not in judgment. This could be true if the justices are using the word judgment to refer not simply to coming to a conclusion, but to arriving at a binding legal determination. And I do think that there is, about the use of the phrase reasoned judgment, a kind of resignation, as if the justices are saying they cannot avoid the case, deciding the case at hand, and therefore cannot avoid evaluating the moral positions implicit in tradition and practice. And reason, they are saying, almost sadly, is all they have to rely on in coming to their legal judgment. But the need for legal judgment is not at issue. What is at issue is how that judgment should be made. Reasoned judgment thus seems to mean no more than that the justices are convinced after sober reflection that their opinions are superior to those embodied in history or practice. If so, there is no restraint in the relevant sense. There is no restraint in the sense of deference to the judgment of others, even when the justices disagree with those judgments. That is, when they want to and are inclined to displace those judgments. It is when you want something, when you are impelled to something, that is, do I have to say it, exactly when the capacity to restrain yourself is necessary. If you agree with the wisdom, if any, inherent in history, you don't need to restrain yourself to abide by it. All this raises the possibility that the term reasoned judgment is an empty term, a failure of imagination, a failure to imagine the possibility of deferring to judgments held by many others in many circumstances, even when those judgments seem misguided. This failure on the part of highly intelligent conservative jurists may be explicable, I think, because of the difficulty of reconciling judicial restraint with assumptions about the judicial function, assumptions that constitute the traditions and practices within which the justices operate. So to conclude, one of the questions I want to explore and learn about in the months ahead is what various ideas are available in conservative thought that might fill out or justify or constrain a judge's resort to something called reasoned judgment. Given the court's performance over the past 40 years, I suspect that there may be no such ideas, at least none that can operate effectively in our circumstances. If that is true, A jurist could be restrained only by abandoning deeply entrenched legal expectations that surround the hallowed phrase legal reasoned judgment. And that would be a heresy that might be wise, but difficult to reconcile with conservative instinct and ideas. So that's all I've got to say, almost literally. So I guess Melissa wants to have time for questions and comments and speeches. What's the word? Any questions?
I haven't had anything to write down on, so maybe incoherent. But I'm very impressed by your interest in basically the interrelationship between reason and judgment. And the question of reason especially fascinates me in the days of my doctorate dissertation. In Latin, ratio. And we tend to forget that that's the same root, the same word exactly, as ratio. In other words, it's a relationship between two things. So reason, this is very natural law. Reason is very much a question of relationship, the ability to relate, reflect, and understand reality as it is. Specifically, in this case, frequently human nature, and taking it as a good, as a primary good, and determinative good. And then judgment, I just want to suggest that I find very resonant because it's based on the word use, as you know well, right. And the question which seems to have happened, and you brought it up quite nicely, the Enlightenment, the hubris of the Enlightenment tradition, and presuming that right here, right now, we can use our minds to formulate a new reality which needs no external check at all, no external constraint. And so anyway, I found your suggestions very, very thought-provoking and insightful, and I'm looking forward to where you go in your following months.
I'm not sure if you could all hear that. There was no question. But there was a very interesting and thoughtful
The question
comment. No, I don't want to question now.
It'll only take another 10 minutes.
Kevin's, I want to stop you there and treat it as a question in a way, because a question might be, well, what about natural law and natural law philosophy as a part of conservative thought that might provide a basis for the idea of reason and judgment that works and that can root legal decisions in reality and traditions that recognize the reality and so on, if I'm understanding you right. And that is one of the, along with the common law tradition, that is another part of conservative thought that I have not, that I'm pretty ignorant of, to tell you the truth, except for what I've learned from Kevin over the years. And so it's something I want to look into. I will just make one brief sort of preliminary comment about it, because I am familiar with the work of some constitutional theorists, like Andrew Harkness and others, who are well versed in the natural law tradition. And their work may, and I say may because I've only begun to think about this, their work may indicate that in our present circumstances, that philosophy, whether right or wrong, even if it is well-founded, may not work to restrain the court because it might, at least in the full sort of sense that conservatives like to think of restraint, because it would require massive departures from precedent. So at least there's a potential tension there. So the conservative natural law theorists, and what I'm saying now is just entirely too superficial to natural law people. But as I say, I'm only starting out on this, many of their positions would require, or might be thought to require, the court not only to reverse decades of Supreme Court decisions, including, say, Roe versus Wade, and all the decisions that have made sense, but to find a way to interpret the Constitution to require that states and the federal government protect the life of the fetus as being a human life, because a lot of natural law thinking thinks that's what nature and God tell us. And I'm not by any means inclined to say, oh, that couldn't be right. If I'm inclined anyway, it's to say, I think it probably is right myself. But, again, I come back to how could you be a restrained justice of the Supreme Court to take that position and alter centuries of understandings and practices about who and what is protected to the right to life under the United States Constitution. Because in other words, you'd be forced into a judicially radical position. I don't make this up. A lot of the people who are very thoughtful, knowledgeable, natural rights people, they take this position, that that's what the court should do. They shouldn't just reverse Roe, but they should establish in its stead not a right to abortion, but a right to a free life. And so that's an example of what I just sense about the difficulty. What I tried to communicate by saying in our present circumstances is just very difficult to see how even that conservative philosophy can undergird, can be consistent with a policy of judicial restraint. Yes?
What do you say to the stereotypical 2L Federalist Society?
I should not have called on you. I don't know how I got it.
Let's say something like originalism. You have not said one word about originalism. And if we could all be originalists and somehow bamboozle other people into being originalists, the entire problem you've sketched will not arise.
Well, again, that's the kind of thing I want to look into. I did neglect to mention textualism, what I referred to Scalia, so I thought that was enough. Yes, that's another of the items that I want to look into more thoroughly. But I would just say at this stage, again, as I was saying to Kevin, I would say to your hypothetical eager students that, again, it's just at the beginning level here, it's hard to imagine how that works out with a consistent practice of judicial restraint. Because, as, say, Justice Thomas has argued in a number of areas, the Establishment Clause, the Commerce Clause, if you want to go by text and historical understanding, you must reverse decades and decades and decades of Supreme Court decisions. It may well be that you have to dismantle the much of the modern administrative state, which could be a result devoutly to be wished. And there are, as you well know, people who argue that that would be a desirable thing for the court to do, or at least start to do. And people thought the federalism revival that you referred to this morning was the beginning of that. Justice Brennan was sure that was it. But again, this is a good example. You run the court, you said it fizzled out. It fizzled out well short of ending the modern administrative state, partly because conservatives ran up against their preference for stability and precedent, which is a part of conservative thinking as well. So this is another example, similar to what I gave with regard to the question of natural law. It's textualism and historicism might theoretically, if we had started with that and stayed with that, it might have provided the kind of, old-fashioned, ordinary workaday judges that you were talking about this morning, that don't get into the whole expansive business that we've seen since the middle of the 20th century. But again, the word that I used in my paper is in our circumstances. In our circumstances, it may be impossible to be a textualist and a historicist and also be a gradualist and a person who respects precedent. And if there's any need to prove that, I'm sure there isn't with the students you have in mind, because they're very sharp and they know a lot, but Justice Scalia himself, who took this position as far or further than anybody else has, he, on important issues, said it's too late to reverse all the precedent. I have to vote to extend these decisions, to uphold these decisions, even though they're not consistent with the text and history. Because why? Because I'm a conservative. He didn't necessarily put it this way, but because I'm a conservative and I believe in stability and precedent, and we can't just take apart the present manifestations of the New Deal. So it's just very difficult for me at this stage, without having really looked into it further, to imagine how could you? You could be a radical. And I think Justice Thomas, for example, might well be an example of this. A real radical thinker, although even he, if you look at the Commerce Clause cases, he makes this radical critique, and then he says, but it's too late to overrule all these decisions. I'm just telling you this, he said, what the real meaning is just to get it out there, sort of like a law review article. But, so that's the kind of problem I see. Yes, sir.
Okay, so in your view of the Constitution,
I don't know what rationality explains segregation.
different question. When a state statute that criminalizes, for example, charges a woman that has an abortion in the first trimester, in your view, would that be constitutional for killing the fetus?
Under what assumption? I'm sorry.
I'm asking you under your view of the Constitution, when a statute, a state statute, let's say the state of Colorado enacts a statute that says that a woman who has an abortion in the first trimester commits murder of that fetus, would that statute be constitutional in your view?
Well, as a current
No, I'm not.
candidate for the presidency has said, well, that's a hypothetical, since currently everybody knows that's illegal to do. But I'm not going to answer it that way, since I'm not running for anything. I would say, you want my opinion? My opinion is that Roe versus Wade.
No, constitutional or not, in your view.
I'm giving you the answer.
Not under Roe versus Wade, in your view.
It's, in my view, that opinion is constitutionally incorrect.
Well,
I side with Justice White that it was, as he implied, that it's an exercise of broad judicial power. And so as a couple of people suggested this morning under questioning, I tend to take the view that we've lost sight of the fact that there are many, many injustices in this world that the Constitution does not resolve or prevent or even remotely have anything to do with. And it would be far simpler and more intellectually honest if we just said, look, the Constitution doesn't bear on that question, on the question of abortion. It does not bear on it. And therefore, if it is true that women should not be, that their behavior in the first trimester of pregnancy should not be criminalized, then we better get busy and find a way to protect that right in the political process or in some other way. And we better make that argument to our fellow citizens, because if that argument is compelling, I was going to say it'll prevail in the political process, but actually it's sure to lose if it's compelling. But passing that. Anyway, the serious answer is that I don't think the Constitution bears on it. And
So that statute would be constitutional if declared a woman,
yes.
to be prosecuted as a woman in the first trimester. Okay.
Well, that happened. That happened. That was the wonderful world we used to live in. Yeah.
So, Bob, does the difficulty in amending the Constitution affect your view at all about how much restraint the judge should show in these kinds of cases? I mean, I think it's objectively true that it's difficult to amend the Constitution.
Yeah. Although apparently not difficult enough if you think about prohibition and a few other examples. But I have to think about it, because that's a potentially complicated question. But I would just say off the top of my head that no, it doesn't affect it. If you're asking, which you're not, but if you were asking, is this a reason why we probably have come to rely so heavily on interpretation, I would say yes, it probably is one of the reasons why. And there's work that's been done on that, comparing state constitutions that are easy to amend and the federal constitution, which is hard to amend, and patterns of interpretation in those two jurisdictions. So people have worked on this. I'm saying probably it stands to reason, there's probably a relationship there. But do I think that the difficulty of amending the Constitution justifies the sort of thing the court's been doing? No, I don't think so. Anything else? No.
I'd just like to take a moment to say thank you. I wanted to come here today as a former student and thank you for your work at the university. I know a lot of your former students are here, but also as a member of the CU Board of Regents, I have the privilege of officially thanking you on behalf of my fellow regents and this university for your 40 years of service. I think you've done a tremendous amount to raise the prestige of this law school and this university, and you're going to be sorely missed. And I'd like to ask folks to join me in a well-deserved round of applause.
Thank you very much. Thanks again.